this video, we are going to talk about law in the early Republican period of the Roman world. So we're going to look at a couple different aspects of this, including how a law is made, but then also how disputes are settled using the legal systems that the Romans put in place at this time. So I actually want to start by talking about a law code. For the earliest part of Roman history, there was no formal written law code. When there was a dispute between people or when a crime had to be addressed, a magistrate oversaw those proceedings and he made his judgment based on his own sense of right and wrong, or probably often his own biases, or whatever he thought he wanted to do. So there is a system here that allows for an incredible amount of bias and corruption in it. And so we saw that as part of the conflict of the orders, one of the things that the plebeians asked for in 451 BC was a law code, a written law code that everyone has to obey when you have like a trial or a court case, right? We know what the rules are and the consequences and all of this stuff. And so we said, okay, in 451, the Romans, they actually appoint a group of 10 men called the decemvirs, and they are sent to Greece to learn about law codes. And they end up producing what are known as the 12 tables. They're called this because they were written out on 12 tablets. And those tablets were posted publicly so everyone could see them. No one could change them or alter them secretly. The 12 tables, the actual physical tables, are long gone. We do have records of some of the contents of the 12 tables based on what later legal authors describe or quote from them. So we don't have the full thing, but we do have some example of what the 12 tables were about. And we're going to take a closer look at that in our with our in-class discussion and the reading you're going to do for that class on ancient law codes. So I want to turn next to the way that laws are made. And so I want to actually make a distinction between three kinds of law or policy that the Roman government is capable of producing. So one is the lex. That's just Latin for law. That's the sort of standard kind of law. One is the plebiscite. We talked about that a bit. We'll review it again here. And then the last one is the senatus consultum. It means like consultation of the Senate. We can just call it, we can just call it an SC because it's long. And so I want to talk about how each of these is formed and what each of these does, because all three of these can exist within the Roman world. So the lex is the basic law. It is a law that's proposed by the Senate. A senator or a member of the Senate will propose some kind of bill for something that they think should be a law of the Roman world. And it is then sent to the assembly to ratify, right? The public assembly of citizens, they vote on it. And if they approve it, then it becomes an official law. And it binds all citizens, right? Everyone has to obey this law. So that's really basic, straightforward kind of Roman law. The plebiscite is more complicated, as we saw. So the plebiscite is proposed actually by one of the tribunes of the plebs. We see that's a magistrate who has to be a plebeian, who looks out for plebeian interests, and among their powers is vetoing a lex that they don't like, that they think hurts the plebeians. The other thing they can do is introduce proposals of a plebiscite. So their proposals are voted on by the Council of the Plebs. Maybe I should specify here, it's that curate assembly that votes on laws. I'm sorry, not curate, centuriate. Too many assemblies in the Roman world. And so the Council of Plebs votes on it and ratifies it. Now, whether or not it becomes a law that binds everyone really depends on the time period. So originally, it just bound the plebs, right? When it was first introduced, one of the tribunes could introduce it, the Council of Plebs votes on it. If they vote yes, it is a law that binds the plebs, but it doesn't affect the patricians. Now eventually they say, okay, if it passes the Council of the Plebs, and then it passes the Senate, then, like the Senate votes on it, approves on it, then it is binding on all citizens, right? It's identical to a regular lex. Then by 287 BC, they changed it again, right? And they said, okay, if it's just the Council of the Plebs, even without the approval of the Senate, a plebiscite still is binding on all citizens. So that's starting in 287. So this evolves over time. The Senatus Consultum is something we haven't talked about yet, and I will mention just now so you have a sense of it, because we'll look at a couple of these as we go through the history of the Roman Republican period. So Senatus Consultum is proposed in the Senate by one of the senators. It's a recommendation that they have proposed. It is ratified by the Senate, and it binds no one. It's just something the Senate thinks Rome should do. It's usually framed as advice to a magistrate, like the consul. This is advice on how you should proceed with your job, what we think you should do. You don't have to listen. That being said, most magistrates do listen because they are members of the Senate, or they are connected to the members of the Senate. They have many allies among the Senate. So Senatus Consultum is not legally binding. It's just a recommendation the Senate makes for how a magistrate should carry out his duties, but it's often listened to. So we find examples of these Senatus Consulta in Roman history that, while they're not laws, they were carried out quite frequently. Okay, so those are three kinds of types of law that the Romans are capable of creating. So next up, I want to talk about how we have a trial. So the law code is there for us to follow, but what happens when there is an issue and there's a problem that needs to be resolved? Well, first of all, we are going to make a distinction between private and, we'll say, criminal law. Right? A private law issue is a dispute between two people. Whereas a criminal issue, in theory at least, affects the entire community. This is not a very strict line, and it often depends on your way of thinking. In the early Republican period, there's really only two crimes, and that is murder and treason. Everything else they see as a dispute between two parties, right? Theft, that's a dispute between two parties. That's between the thief and the victim. Assault, that's between the two people who were involved in the fight. Anything like that, that's not a crime to them, that's a private matter. And so there's not a very well developed criminal law and criminal law sort of procedure in the ancient Roman world. If someone is accused of a crime in the ancient Roman world, then the magistrates will appoint what are called duumvirs. It's a board of just two men who listen to the accounts and who make a judgment. And both of those crimes are punishable by death. Okay. Although eventually those people get the right of appeal. If you are sentenced to death, you can first appeal to the Centuriate Assembly to hear your case and vote on whether or not you will actually be executed. But that's criminal law. It's not, like I said, it's not very well developed at this point because they have so few acts that they consider crimes. It's fairly rare. Private law is much more robust. And so we're going to spend more time here focusing on private law. I'll just get rid of that too. Okay, so the way that they resolve disputes between two people in private law is a system that is called, in Latin, the legis actio system. It just means an action of law in Latin. It is essentially established in the 12 tables, and it is in use in the Roman world up to about 200 BC when it falls out of favor. So what do we do if we want to accuse someone of an injury, a personal injury, whether it's a physical injury or a property injury or something like that, right? Like we said, there's a very wide range of things that could be a dispute between two people in the Roman mind. So first up is the summons. So the plaintiff, the person with a complaint, he summons the defendant that he's accusing of something to appear before a magistrate. Eventually, this is the urban praetor. Earlier on, it has to be someone different, but the urban praetor is kind of created so that he can fulfill this jobs. And so the plaintiff summons the defendant. What if the defendant says, I don't want to go to this trial? You can use force. You as a plaintiff can get some friends together and force the defendant to show up. And so you are summoned to appear before the magistrate. And so now you have this sort of preliminary hearing with the magistrate. Again, eventually this is the urban praetor. Especially if you're fighting over a thing, like you both claim that this cow belongs to you, right? Then you bring the thing with you. The thing disputed should show up. Now, sometimes you cannot bring the thing that is being disputed because it's a chunk of land, for instance, in which case you bring a token of it. So if you're fighting over an acre of land, bring some earth with you. Bring a pile of soil with you. Something like that. To start with, each side in turn, they have a special rod. They lay the rod on this thing that is under dispute or a token of it, and they each make a claim. And in that claim they swear, this is mine, I'm correct about this, and I am staking a sum of money to show that I'm serious about this, right? If you prove me wrong, I will forfeit this money. So they're each kind of like betting that they're the one that's right. And the 12 tables actually tells you how much money you have to bet in these situations. It's a certain sum. Okay, at this point, the praetor says who's going to hold on to this thing until the actual trial date comes around, and they write out very formally the issue at hand, and then the praetor, after 30 days, they have to appoint a judge. Why do they wait 30 days to appoint the judge? Probably because they're hoping that this blows over, and they don't have to worry about it, that these people come to a resolution on their own. But after 30 days, the judge is appointed. The judge has to be approved of by both sides, so that it's not someone who has a real bias against or for one side. And then they set a trial date when the judge is going to hear this. Judges are not a trained class in Rome. They aren't a special kind of magistrate. It's just someone that seems to be like someone you look up to. It's probably going to be someone from the patrician class, someone who has a certain level of power and esteem associated with him. So, at the actual trial, the judge hears the arguments from both sides. If you don't want to make the argument yourself, you can have what's called an advocate. An advocate's kind of like a lawyer. He writes a speech and delivers it and defends you or prosecutes the case on your behalf. You can hire an advocate to do that for you. You can present witnesses and any other evidence that you have. The judge hears all of this, and then he makes his decision. The decision's final. There's no appeals in this case, so you get what you get. At that point, the person who has possession of, who has been awarded possession, can claim it. And so if he's the person who got temporary possession, nothing has to happen. There are cases where you have to go and get something from the person who lost, right? Let's say you're the plaintiff and you won the case, but the defendant is the one who is holding whatever it is that's under dispute, let's say a cow. In that case, you are in charge of getting it yourself. The government isn't going to step in and help you get control of that cow. Instead, you're on your own. Now, after 30 days, if you can't convince the defendant to hand over the thing under dispute, then you can, again, take this guy forcibly to the magistrate. He can be held in jail until he pays up. And he may even be sold into slavery if he refuses to pay his debts. So there are eventually some kind of consequences, but you really do have to step in and act in those cases. Now, there are issues with the Legis Actio system. One, it's too technical. It's really rigid, I should say, I think. We have an example, for instance, of a man who sued his neighbors because they cut down some of his vines, like his grapevines. And in the complaint that he made, he wrote vines. They cut down the vines. Well, cutting down vines is not covered in the 12 tables. It's not a law. There is a law about cutting down trees. And so the magistrate said, well, you lose because I don't have a law about vines. You should have written trees, even though they're not vines, they're trees. So it's this kind of like nitpickiness that can be really aggravating. The other issue with the Legis Actio system, it is only applicable to Roman citizens. If you are not a citizen of Rome, you cannot enter into a Legis Actio case. This is not an issue early on when there's just Roman citizens in Rome, but as Rome grows, there's going to be many, many more interactions with other peoples in Italy that are not Roman citizens, including business transactions and being neighbors, and that's going to lead to conflict. So what do we do in that case? Okay, so the Romans decide to address that eventually. In the early 2nd century BC, they develop a new system. We know it's called the formulary system. And it is developed by the Peregrine Praetor. The Peregrine Praetor, it literally means foreigner, praetor for the foreigner. The urban praetor is the praetor for the city of Rome. And his job is to deal with law cases that involve foreigners. So it could be a citizen plus a foreigner. That's the kind of law case that he oversees. This is a magistracy that's established in 246 BC, and then as he realizes that the Legis Actio system cannot help him, he develops the formulary system over time. So what the praetor here does is he essentially took the law code of Rome and he wrote up a series of formulas based on the law code. And these formulas are just possible charges you can bring against someone. So when you want to make a charge, you look through the list of formulas. And these formulas are published every year. It's called the Praetor's Edict, and so it's available for anyone to look at. So when you have a complaint, you look through the Praetor's Edict, you find the formula that matches yours, and you can make that complaint. And this way you don't run into a situation where they say, oh, your complaint isn't correct, that's not based on the 12 tables. You now have a list of all possible complaints you can make. So it solves that issue. Otherwise, it's very, very much like the Legis Actio system. You have the summons. Originally, again, you summon a defendant to show up before in this case, the peregrine praetor. Although now, if he refuses to show up, you can complain to the peregrine praetor, and he'll order the defendant's property seized in that case, if he doesn't comply. When you have the sort of preliminary hearing, you don't have to do all the sort of formulaic ritual stuff with the rod and the swearing and the bet that you're making, the stakes that you have to offer that you're correct. Instead, you sit down together and you write a formula. You take the kind of formula that's in the Praetor's Edict and you personalize it. So the plaintiff will write in his claim, the reason why he thinks that he's right. He will name a judge that he would like to be there. The defendant has to approve it, but they agree on the judge. He gets named in the formula. The defendant can add his own claim and his defense as to why he's not guilty or he owns the thing that is under dispute. And so they put together this formula based on the formula from the edict that perfectly describes their case and the major points of it. At that point, if it's a real obvious case, the praetor will solve it immediately, but otherwise he will appoint a judge, right? Usually the judge that the plaintiff and defendant have already agreed upon in the formula. And so then we get to the trial, and the trial is the same. The judge hears both sides, you can have witnesses or evidence, you can have an advocate speak for you, and at the end of it, the judge makes his decision, and that is final. There is no appeals court. And so it's basically the same system, but instead of this very kind of ritualistic claim that we see in the Legis Actio system, we have this formulaic system here where we pick our formula and then we personalize it for our case. And so we don't run into the issues that we might run into when we're writing kind of our own complaints. And then, of course, the other big one is non-Romans can use the system. Now, it's so much more efficient that eventually the Legis Actio system is completely abandoned. And we know that in 145 BC, something called the Aebutian laws passed, and the formulary system officially replaces the Legis Actio. It is used for both citizens and non-citizens. Okay, so that's my overview of this early Roman law, and especially the way that the trials take place in the Roman world. As we go along, we'll see there are some changes to it, and criminal law will get more complex as time goes on as well, so we'll revisit the topic later. All right, thanks for watching. Bye.